right. Welcome, everyone. I am super excited tonight to be meeting with Mike, Noah, and all of you. We are going to learn some good things about finances, the fundamentals of estate planning. And so we have a handful of people that are in here who just have their cameras off, and then at the end we can turn them on for question Q&A. And we've kind of been discussing a little bit at first, but if any of you who are in here have any questions, throw it into the chat, and if Mike doesn't see it, I'll get his attention. Okay, so I'm going to share the screen then, and then I'll just turn the time over to Mike in just 1 second. The only thing really that I wanted to say, first of all, I want to tell you a little bit about why I'm doing this. I'm in the Thriving Singles community. It is for a group of singles who are between roughly the ages of 45 to 60-ish, 65-ish, around there anyway. So we do just a lot of training, educational discussions. We also do personal interviews for life stories and such. And I had a discussion, I put a chat, just one of the posts that I put in that group was about prenups. And we said, yes or no, prenups. And everyone, there was probably only 2 people in there who said they would not consider doing one. And everyone else said they would. I think there was about 60 comments in that post. So it tells you it's really important to people. And so that just motivated me to want to learn more. Why are people so excited about doing this? And what are the pros and cons of it? So I reached out to Mike. I know he's an attorney, and in the past he had spoken to me or reached out to me about these things. So anyway, I'm so grateful he's joining us and he's doing this for us today. All I know about him as far as his credentials is that he has 34 years of experience as a lawyer, but I know there's so much more than that. He's practicing in Kansas State. So he only will give personal legal advice to his clients. And so if you have personal legal advice, he would just advise you to talk to an attorney in your state that knows your law and can legally practice and give you personal advice in your state. So anyway, turn the time over to Mike now, and you just take it away. Thanks for being here.
That'd be great. You can go to the first slide if you like. Just a little bit about my qualifications. We don't need to, you already got you already see me anyway, so you don't need to look at that, look at that headshot. My undergraduate degree is in journalism from the University of Kansas. My law degree is from Washburn University School of Law. I finished my last year at what is now Seattle University Law School and spent 25 years practicing law in the state of Washington. I'm no longer licensed there. I let that go when I came to Kansas because it didn't make sense for me to do it because I wasn't really marketing there. You know, you practice where you are. So I've been licensed here for the last 9 years or so. And really, I've got a broad background in things. I don't do intellectual property and I don't do intensive tax work and tax planning, but kind of everything else I've stuck my fingers in somewhere. But I've done a lot of family law and a lot of litigation. And so I'm happy to present some things here that I hope will help you. As Sheri indicated, these are going to be relatively general comments because I don't know where you're from. I don't know what your specific issues are. And again, if I got too far into them, I might run afoul of the rules against practicing law in jurisdictions where I'm not licensed. And so that is a problem for me and you. And so I am going to try to avoid that today. So let's just dive in with that introduction. Now, there was a lot of talk about prenuptial agreements in this community conversation that you were having. And I just want you to be aware it's not the only kind of agreement that can be entered into when you are in a relationship. Most of these comments that I would bring to you certainly would apply in a marriage, but they'd also apply in any other kinds of relationships that you might find out there in states. States that recognize common law marriage, for example, and those that don't. These would apply to same-sex couples. these are not principles that are exclusively to a heterosexual marriage. And I just want to be clear about that, because really the law treats them pretty much the same in most jurisdictions. So not only do you want to think about making arrangements with your spouse prior to marriage, but you may have things that happen to you after the marriage that you might want to talk about and put into an agreement. Let's talk about the prenuptial agreements first. And really this works for pre and post. What a pre and post nuptial agreement is a contract. They're essentially contracts, and we'll go into that in more detail as we go through our discussion here. Clearly, when you have a prenuptial agreement, it's got to be before the marriage. And clearly, a postnuptial agreement is agreement you enter into after the marriage. So the dividing line there is the marriage, anything before and anything after. The reason you might want to enter into these agreements is to clarify how you want to treat property and what character you want to assign to it, so that there's a clarity between you and your spouse. In general, because it's likely that we're dealing with people that this would be either a marriage later in life or toward the middle part of life, or a second marriage or more. You may have property that you've acquired and you want to make sure that you have some control over it. That's really what we're talking about here, and we'll again talk about that in more detail as we go along. Now, how you go about it? Well, I guess you get a pen and a piece of paper, and you could sit down at the kitchen table and you could both scribble it out, but I don't think I'd advise that. Trying to do your own legal work is a little bit like trying to do your own open heart surgery. It's not something I would recommend, but it can be done, and it doesn't mean that you have to do it that way. However, I think that you should be aware that you're dealing with a contract. And so, since we're dealing with a contract, no matter who enters into it, has to have certain requirements for it to be valid and enforceable. One of those things is the parties have to have a mutual agreement. And that means not only that they agree to agree, but they agree to agree about specific things. So if one party thinks it's one thing and the other party thinks it's another, you don't have a mutual understanding. So that's where I think legal counsel can help you sort those things out. Again, you don't have to, but if you can have an idea of what you want to discuss when you go into a meeting with an attorney, I think that can help you. Contracts also have to be supported by what's called consideration. And I don't want to go too far into that and make this a law school class, but consideration is doing or not doing what you have the legal right to do. In most circumstances, you're going to have the legal right to talk about property throughout both of these pre or post nuptial situations. I say that with a caveat because in some community property states that may be different, and we will talk about that a little bit more as we go along. So one of the things that the slide tells you is that when you talk about mutual agreement, there can be defenses to the formation of a contract. One of those is undue influence, and the other is duress. So the undue influence aspect says that if a party exerts an undue influence and tries to talk to somebody into entering into an agreement with them that is clearly not in their interest, for example, or they clearly have more power in that circumstance, that can void the terms of the agreement. They weren't necessarily voluntarily entered into. And duress is just kind of heightened undue influence. It's nice house there, nice business there. It'd be a shame if something happened to it. That's duress, right? So those things can happen, and they often do in these kinds of circumstances. So that's why I think it's important that if you're entering into these agreements, that you may consult an attorney and you will have both sides have their own independent, review of this, and provide them the opportunity to have counsel look at them, so that those kinds of undue influence and duress situations don't necessarily show up, because lawyers are attuned to these things, because
Yeah.
they don't want to draft a contract that isn't going to take effect. And this is one of the areas that I always looked for when somebody presented me with a prenuptial agreement, usually in the context of a divorce, and said, well, we have this prenup. And besides sitting up straight in my chair and going, oh, goody, because I wanted to see, what areas were going to be a problem, because these are contracts and nobody drafts a perfect contract. I wanted to see if those other factors like undue influence or duress took place. And when there's unequal bargaining power between the two parties, these kind of things can show up. So for example, if you have one party that's wealthy, the other one's not so much, the incentive might be high for the party that doesn't have quite so much to indicate that they're willing to go into this relationship when they're really just trying to get some some idea of security, and not, take advantage, be taken advantage of if they're alone. And so those kinds of things can come in. So that's what I would caution you about, the when, why, and how is you want to make sure that you know the reason you're having this agreement, and you want to make sure you know what the motivation of your partner is in forming these agreements.
And then I have a question to interject
Yes.
right now, but I'm wondering if you have marriage counselors that can say, you might want to reconsider marrying this person. He's or she is.
Sure. Well, sure. And that would actually be a conversation that you could have with an attorney would have with you as well, because if they looked at this and said, well, do you understand the effect of what, you're talking about doing here is, that's going to be the benefit of using an attorney. They're going to ask you, do you understand the benefit to you of doing this, or the detriment to you of doing this? And I think a counselor can certainly do that, more from a standpoint of they're kind of pushing you around here. Maybe you don't want to do that. But I don't think that I would listen to my counselor for legal advice, just as you shouldn't probably listen to me about how to handle psychological issues.
That could be anyway. Those are some of the reasons. I'm glad you brought that up, because that's how I view the prenuptial. That's why anyway, just something to consider. How are you being treated? What are their motives? What are your motives? Because I think that would also tell you a lot about the character of the person you're about to marry too. So anyway,
I agree.
This is very sensitive for me and for maybe others, just to be careful. Anyway, how it works out for your favor or theirs. Anyway.
Very good. I agree. So let's go into the next kind of topic. And some of these things are going to blend together. You may think I'm hitting with the fire hose, and maybe I am. But a lot of these things playing together, and we need to get an idea of what's there and what you can utilize to see how it kind of fits together. Okay. There are really four main components of a good estate plan, other than these pre or post nuptial agreements that we talked about.
Okay.
One of them is an advanced directive or living will. You probably heard of these. You probably even have them. That's good. A living will is the product of some case law that developed in the late 1970s, early 1980s, because people were living longer, and medical science was able to keep people alive in circumstances they might not have survived before. But often in circumstances in which they couldn't speak for themselves. So doctors would be reluctant to do really anything, even though they said, this person is not here. We need to do the compassionate thing and let them go. Families didn't want to do that. And there were a number of different fights and things that came out over the years. And some people were kept on life support for a very long time, years and years and years. And so the law developed through cases like that, where you can tell anybody but mostly your physicians in advance, how you want to be treated if you have a terminal condition and can't speak for yourself. That's up to you on what you choose, whether you want extraordinary measures or not. And if you let your physician know in advance, then they can rely upon that if you execute that document correctly. It's usually governed by a law that's passed by the legislature in your state. You can probably look it up and find out and do that yourself if you want. But really, a good attorney is going to do all of these things you see on your screen. So just keep that in mind. But that takes care of a circumstance in which you're alive and you may not be alive for long. Okay.
Yeah.
The power of attorney for healthcare covers a situation exactly what it sounds like. It covers a situation in which you might need someone to speak for you to direct your healthcare. You may still be coming out of surgery or something like that, and you can't give informed consent. This is important, and most doctors want to see these days because they're pretty smart guys and gals, and they've been educated both in the ethics and legal aspects of how they work. So if you have one of these and you can put it on file with your doctor or have it ready for the doctor in case they need it if you're hospitalized or something else, it's a very powerful document. The next one is the power of attorney for personal business. Again, this is something that's really important, not only when you're incapacitated, that we'll talk about in just a minute, but it's an important document to have so people can handle your business affairs if you're not able to take care of them. This can be as simple as depositing a check in the bank. All right, so it's important to have that in place. And lastly, I think some of you talked about trusts, and we'll get into trusts in just a minute, but really the key document for you to think about having is a will. A will says what ought to happen to your stuff or what you want to happen to your stuff once you leave this life, and the stuff don't mean anything to you. So we'll be talking about that here in just a moment. So an advance directive, as I said, is a formal written statement. So you got to write it down. Typing, really, have it typed out, have it word processed out, and then sign it. And the law in your state will tell you how to do that. And it has to be done when you're competent to do it. So if you're, semi-comatose and somebody shoves one of those in front of you and you sign it, it probably is not going to have much effect. So you want to think about it in advance. That's why it's an advance directive to your physician. Now, it's not a do not resuscitate order. Those are separate. A do not resuscitate order is an agreement between you and the medical facility you're in that gives them some legal shield if they comply with your wishes. If you don't want to be resuscitated, they're not going to. They can rely on that. So that's a little bit different. It's not the same. And the advance directive covers all circumstances. The DNR would cover a circumstance with a specific provider, mainly a hospital.
Okay. Yeah, I remember I used to work at the hospital, and I would encourage the patients to do the advance directive. And I remember DNR being a part of that. So yeah, the advance directive, is that something that typically is signed before you go into surgery or something like that? Is that usually?
Oh, yes. You could do an advance directive. You should do one tomorrow. I mean, if you don't have one, arrange to get it done, because it doesn't take effect until you can't speak for yourself. So, nobody's going to come in and say, aha, you got this living will. I said, yeah, I'm still alive.
Yeah.
And I can speak for myself, and I ignore that. Yes, I want that surgery or whatever it might be. So that's one of those things that you can have and keep until you need it, or you can supply it to your medical provider. All right, there we go. Medical power of attorney. Yeah, again, these are one of those things that I advise you to draft them so they're effective immediately upon your signing or execution of the document. You can put a provision in that says it only applies when you're incapacitated, but that really doesn't make much sense, because then you have to have somebody declare you incapacitated. are unable to speak for yourself, which puts another layer involved in this. And if a physician doesn't think you are, then they're going to, rely on this documentation, but somebody else may think you are. And so what you're setting that up for is some judge to make a decision after somebody runs to the courthouse trying to get an injunction against somebody else. And that's not the point of having these medical powers of attorney. They're there so that they can be utilized. And really, if you're competent, nobody's going to come in and say, where's your power of attorney?
Yeah.
That's not how that works. Your physician will be able to get at least a basic idea of your competence. And so what this document does, as we discussed, is that it allows somebody else to make medical decisions for you. So somebody that you trust, that you have a good idea will know who's going to make the decisions that you would have made had you been able to make them. It can be a family member, it can be a friend, it can be, I don't know, an acquaintance, somebody that will be available as well when these decisions need to be made. For example, if you have a child that lives across the country and they may or may not be able, maybe in a different time zone, and they may or may not be available when these decisions have to be made, probably not the best choice, but not a bad choice. And certainly if they can be contacted and you provide a contact information within the document, that's okay. But I typically say choose people around you that know how you think and feel. So again, the personal business power of attorney, these things are very extensive and usually very powerful. They let people be you when you can from a business standpoint. They also come in handy, for example, if you're moving to another city and you need to sell the house, but you and the spouse own the house, and somebody's got to sign the document for you both so you can get the thing in escrow and you don't make 2 mortgage payments and all those good things. And if you grant that power to your spouse who's still in that state, they can sign that document for you. And it also helps if you're in the hospital and, for example, you got to pay your car insurance or your house payment or something. Somebody can go in and make those arrangements for you while you're in the hospital when you probably don't feel like doing any of that kind of stuff. So again, it's somebody that's going to step in and be you when you can't be you, but from a business perspective. It doesn't have to, and in these, I wouldn't necessarily say it needed to be the same person that would do the same function for you on a medical standpoint, but it can be. It doesn't have to be, but it can be. And so, again, somebody that's in proximity that is going to know where to find your stuff, right? Know where to find things so that they can talk to you about it or talk about somebody else. The next one, the last one, of course, is
excuse me, I got a question. Would you go into limited power of attorneys for specific items within a business or even with your healthcare?
Limited power of attorney. Well, I have executed some limited powers of attorney for people in business situations, but that would have to be on a case-by-case basis. And I'm not in favor of limited powers of attorney nor springing powers of attorney, because I can't foresee every circumstance that's going to happen to anybody, and neither can you. And
right.
if you do that, you're hamstringing the people that are there to do the thing you want them to do. And I'm not in favor of them. I think that these things can be super powerful, and they're not all that often abused. If they are, certainly there's remedies for that. But I think that the preference is to give people the power to do things for you because that's what you want them to do. Okay.
Right. I was just thinking I may not want the person that I have for my advanced directives be the same person for my business.
Oh, absolutely. And that's totally fine. The medical power and so forth, the advanced directive doesn't name anybody to do anything. It's purely your statement to a third party. But the medical power of attorney and the personal business power of attorney, they don't have to be the same people. And it's fine if you break them up. It's got to be somebody that knows how to perform those two functions. And it doesn't have to be the same person. And sometimes I suggest, given a person's circumstances, that it's not. So it's going to depend a little bit on your circumstance, and you can certainly have alternatives within those documents. You know, you're going to have, and I suggest that people do, and at least one. So if the first person can't do it, the second person might be able to. And if they can't for some reason, a third person can. So you want to make this as powerful and expansive as it can, because it's for your benefit. And, you know, those kind of issues you raised make sense to me. So
Thank you.
you bet. Let's
And
move
thank
on to wills, so we can cover that ground, and I'll answer as many questions as I can as we go on. The key thing to remember with a will is that, like these contracts, you have to have some voluntary nature to what you're doing, right? It's called, in legal terms, detached donative intent. You have to know what your stuff is and know what you're doing to provide for your stuff after you're dead. That's what it means. So a lot of litigation you get into when people have problems when they're deceased is that somebody thinks that grandma or mom or whoever, that you know, the sister or the uncle or the cousin who ended up with more stuff than you think they ought to have, you know, got mom to change your will. Well, those things can happen, and certainly I've had circumstances where I've litigated those issues. And that's why it's important to understand that if you go to an attorney, they should be looking at this aspect of it, and they should be looking to see if that person is competent to do what they're doing. You know, if they're oriented to time, place, and manner, if they clearly understand what it is they're coming in to do. Generally, if they come in with a relative, I say, the relative, you stay out in the lobby and listen to our music, and I'll have our conversation with this person here who's my client. You're not the client, and you'll find out soon enough what happens. Because, you know, you can always share what's in your will with people if you want, but you don't have to. That's
when you tell them you're gone, then you have let them fight it out.
right. And there
Yeah.
are formal rules for execution and validity of these documents. They have to be signed in a certain way. Depending on your state, you may be able to do what's called a self-proving will. That is having the signature of people that signed the will as your witnesses indicate that they saw you signing it, so you don't have to go find them. If the will has to be proved in court and somebody can test it, you got to go find the people that signed the will. So you want to do that, and a good lawyer will be able to guide you through that process. Preterminate heirs are another issue that lawyers will find that you probably don't even know what that means. Raise your hand if you know. Don't know. That's a rhetorical question. Unless you've been to law school, you have no idea what that means. This is a circumstance in which you don't specifically mention a person who would be an obvious object of your detached donative intent. For example, if you forget to mention you're married in your will and you make no provision for your spouse, that provision of who you hand this stuff is not going to work. Most states will invalidate that distribution because you cannot, without specifically saying so, ignore your spouse when you die, because you can't ignore them when you're alive. If you're married, I mean, you have an obligation to support your spouse. So this kind of flows from that. And so you don't have to give anything to your spouse, again, with a caveat of community property states. And with any luck, I'll get some more extended time to talk about those states. You need to make sure that you are not forgetting people. This applies to, say, children, parents, you know, maybe not grandchildren, because that's a little extended in as far as the line of inheritance, but definitely children and spouses. If you don't want to give anything to your son because you just don't like your son and you don't think he should deserve anything, then don't give him anything, but mention in your will you're specifically making no provision for that particular child. The beneficiaries are the ones that are going to take under your will. There may be heirs, they may not. A beneficiary could be your church. I'm going to leave all my property in my church. You can do that. If it belongs to you, you can leave it to whoever you want to. But beneficiaries can be heirs, but heirs aren't always beneficiaries, if that makes sense. So you have to decide who you want to leave your property to. All right. And as part of that, you're going to need to find somebody that's willing to probate this will. And those people are called different things in different states. We still use the 19th century term in Kansas of executor and executrix. They're gender-based, they're nonsense, and they should never be used again, but we use them. And so that's what we do. Personal representative is a much better term. In many states, it still applies to somebody else in other estate planning capacities that we're not going to talk about today. And so it may confuse certain judges if they're in probate, and they may not know who you're talking about. So you'll want to have your attorney draft it and not worry about it. But this is the person that collects all your stuff, either figuratively or literally. Goes through your house and inventories it. That's the literal. The figurative, they go and find where all your bank accounts and investments accounts are. And they pull it together. And they then pass it out according to the terms of your will. This is the caution about these powers of attorney. And really, if you forget somebody in the will, it's kind of the same thing. And if you get to name a personal representative, if you do this thing yourself, a judge is going to have to make the decision of who's going to do it, right? So that's why I think that you want to make the powers of attorney effective the minute you sign them. And certainly you want to identify all the people in your wills. So we had some questions about trusts. And we're going to talk about trusts a little bit now. And some of you may be disappointed in our discussion about trust, but that's all right. I've been there before, and I know that path, and I know what direction I want to go. So we'll see what questions you might have at the end. And excuse me.
Yeah.
There are generally two kinds of trust. There's really three, but we'll talk about two main ones and touch on another one. This is a trust within a will. That's why it's called a testamentary trust, your last will and testament. It's a testamentary trust because it's going to take property that you have that you identify and put into this trust when you die. There's two reasons, general reasons for it. The first one is if you have a spendthrift that you want to leave money to. And a spendthrift is somebody that is terrible with money, and they'll either gamble it away, or they'll give it away, or they'll spend it on stuff that makes absolutely no sense to their life. And you're concerned about that. Often it's children, but it could be other people. It could be your spouse. You may think that your spouse is going to blow all the money. So you put it in a trust and put provisions in there that govern how it's going to be used for the foreseeable future. The most important one, though, is a trust for minor children. Children cannot inherit property if they are minors. I'll say that again. Children cannot inherit property if they are minors. So you have to have a vehicle if you're going to give specific property to a child. All right. So one of the things that you want to make sure that you do is you want to set up this trust to put your property into if you have a minor child. And that way they can get the benefit of this trust circumstances. A trust is a triangle situation. One leg of the triangle is the trustor, the person who has the control over the property and puts it into the trust. The next leg of the triangle is the trustee. That's the person that supervises the property according to the terms that the trustor sets. And the last leg of the triangle is the beneficiary. That's the person that's going to get the stuff according to the terms of the trust. And you can one person can occupy any two of these legs, but they can't occupy all three. And so in a testamentary trust, you're not going to, you're going to occupy only one, right? And in a normal trust, you might not have that be the circumstance. And we will probably talk about that here in a bit. But you have to understand that you're taking this property, you're putting conditions on it, you're putting it into this vehicle called the trust. You're letting the trustee handle that property, and then you're passing it out to a beneficiary.
That we could ask.
So you've got to identify who the beneficiary is, and you've got to identify who the trustee is in your circumstances, and see which, who you want to benefit from this trust and who you want to oversee it. It's difficult at times to say this is the person you should put in that role of trustee and who as beneficiary, but the beneficiary is usually easy to identify. The trustee is not always that easy. And I think you'd benefit from thinking clearly about somebody that's going to be around during the duration of the trust and that is going to understand how to handle the property in the trust. No. Trusts have to end at some time. They can't go on in perpetuity. There's actually a law called the Rule Against Perpetuities, and without making your eyes glaze over like it does almost every law school since the dawn of time, we're not going to talk about the Rule Against Perpetuities. We're going to just leave it at that. So you're going to have to terminate this trust at some time. And often with a minor child trust, people will say, well, can I just give them the property when they get married? I said, well, sure, you can do that. But what happens to the property if they never get married? And they say, well, I want to give it to them when they're 25. I said, okay, that makes some sense. We can do that. Age generally works. I also have people say, well, I don't want to have them have this money until they're out of college. And I said, well, what if they never go to college? That's a problem. What if they don't graduate from college, but they start a business like Bill Gates and become the richest man on the planet? Is it okay to give it to them then? Right? And so they would have to come in and try to break up the trust, saying, I'm clearly competent to handle this money, even though I didn't graduate from college. So you have to have some thought go into what this is, because oftentimes you think in more prosaic terms, more terms that fit your life and fit what you want to have for goals for your children. That may not be the best idea in the circumstance. So we can move forward. I think we're going to talk about revocable trusts. And we're going to make this discussion short. I'm not a fan. I don't recommend them. Many of you probably look at this and are thinking, oh, great, they're going to tell me how to put this thing or that thing into trust, and I'm not, other than a testamentary trust. I think these are a waste of time. I have drafted them. I have watched people operate under them. I have people done it, say, I have to do this because I've got to avoid probate. All those things to me are nonsense. You can do this and you can shove this into your trust and you can think that there it is and I've got everything handled, but that's what a will's for. And really, there aren't many reasons to avoid probate at all. It's not expensive. A lot of lawyers used to take percentages of estates. That doesn't happen anymore. And it's usually by an hourly fee. And most attorneys are pretty well set up to do it if they do that kind of work. And it's not going to cost you a fortune. Revocable trusts are about control. And they're about you being in charge and right up to the very bitter end. And, you can take it out and you can give it away and all that kind of stuff. And in my opinion, it doesn't really provide you the protections you think it does. And it is not a put it in there and run no maintenance. Plus, you may have some taxable events if you put this in a trust. And I'm not going to give you tax advice. And you best be careful if you do it, because it's kind of like one of those things that if you do it and then try to unwind it, you may be dissatisfied. So I'm not a fan of them. I think that there's an industry out there of lawyers that do these things. and they'll come in and they'll give you a nice embossed book, and it'll have your name on the front and so trust, and it'll look all fancy and stuff, and you can put it on a shelf. But whether it actually does what you want it to do, I'm dubious. And I tried to draft some of these trusts for people because they had legitimate reasons to want to try to do these things. And it turned out almost always that they took it to somebody else because I couldn't get it the way they wanted it. They're finicky, and I don't recommend them. So that's my takeaway on those. If you're worried about, for example, I think one of our questions was, I want to make sure the house goes to my children. Sometimes the question is why. And if you have 3 children, who lives in the house? And how do you divide a house in 3 ways? Well, you can't. And what happens is one of the children petitions to partition the asset, and it gets sold. The most important aspect of all that we're talking about, and I'm going to give you a little bit of example from my own personal life. My parents are 95 years old. They're still alive. My dad mostly lives in the house I grew up in. My mom's been hospitalized now since a week before Thanksgiving. They have all these assets, and they're disparate. And my dad was good at investing and good at diversifying, and everything works real well for them, up until the point that now they need some assets because they're both likely to be in the hospital or assisted living. And so what good does a house do them? It doesn't do them much good at all. No. And they could have looked forward to do that, but they didn't. And so, and not to knock my dad, but he's a lawyer, and he should have thought of these things, but he didn't. Or he thought, like Sheri said, that they'll live forever. There will be no problem. They'll just die in their sleep and everything will sort itself out. Well, we're wrong. I'm sorry, folks, but they're keeping you alive a lot longer than they did even 20 years ago. And with conditions that are sometimes difficult to manage. And so this is not I did my will, I'm done. You've got to keep updated on all of these things because things change. You fall out with the brother-in-law who was going to be the personal power of attorney because you found out he's a crook and you don't like him, right? A child passes away. A spouse passes away, and it changes how you want to pass things out in your will. Life changes, just like the property changes, and you got to change your insurance policy. You're not going to keep insuring the house you just sold. You're going to insure the new house. Well, that's kind of the same circumstance. You've got to update these things as you go along. So with that, I think the last slide we can kind of go to, and then we can get to the very last slide, the next slide. My advice is get a lawyer. It's for your protection. And if a lawyer messes something up, somebody has somebody to blame that's going to have a pocket that can be reached into to redress any of your grievances. If you do it yourself, you only have one person to blame, and that's you. And nobody's going to be there to blame you because you're not here anymore. All right. So I am aware that there are many people out there that claim to be lawyers and can get you a document that will work in all 50 states. And all those kinds of things. You just type in a few things online and voila, you're done. Well, they don't help you execute it. They may or may not get it right. They may or may not know what they're doing. They certainly don't know much about your individual circumstances other than what boxes you clicked on a form. And I'm not so sure that AI is going to be the best substitute for an experienced lawyer. I think that if it were me, and again, I can't tell you how to run your affairs, I would be looking to get legal advice on all of these things. Most attorneys will do everything together in a bundle. They're going to pump out all 4 of those documents for you for the estate plan. They'll talk to you about trusts. If it looks like it's something that's a good idea for you and they want, can do it, they'll help you with that. We didn't talk a lot about postnuptial agreements. and we didn't talk a lot about community property. I think what I'll do is just touch on those briefly, and then we'll get questions. Postnuptial agreements can come into effect if something happens after you get married. For example, you get an inheritance you didn't know about.
Yeah.
It may be important, especially in a community property state, to address that with an agreement between the parties, because in a lot of community property states, you can treat things as separate property, but there always comes into a question about whether it's separate or whether it's not. I think it's pretty clear that it's separate property if you inherit money while you're in a community, you know, a marital community, but there could be misunderstandings about that. And you don't want to have those, because that will lead to the thing you don't want, which is divorce, which really makes things complicated. Anybody been through one of those? You know that those are complicated. So this is basically so you can control what happens to your stuff, and so that you can not have problems with the relevant people in your life. So with that, I'm ready for questions if
No,
that's
good.
what we need to do.
I did want to just close from what we have talked about to
Yes.
say thank you so much for your time, and to let everyone know I will actually put this in our Thriving Singles Community podcast, the audio, and then also on the website, our thrivingcommunity.net, with any other additional resources or anything else that we can add. So for now, we can open up for questions. I am going to turn off the recording. And then, and you guys can turn on your cameras and you can tell us who you are. We did talk to, I'm gonna do two things at once here. We
Sure,
did
you're welcome.
a little bit at the beginning. We talked a little bit about who's here and what people are here for. But if you guys have any other questions, this is a good time. Yeah, I'll push record stop.